good morning. I'm Sanjay Chaturvedi. Uh, very good morning in this on 14th February 2021. Uh, the show is Housing Society Show. We are going to cover in this show basically the Maharashtra Cooperative Housing Societies and its act. The show is brought to you by Maharashtra Cooperative Housing Society Times and Saptakala. Various aspects of the cooperative housing societies which we are going to cover in this show, including the development, redevelopment, taxation, books, charges, parking charges, various other issues, elections, which we are going to bring, and we are going to invite the faculties and learned people to speak to you on various subjects. Today being one of the subject which is burning subject is that the development agreement and termination thereof for the society. We want to understand what are the rights and liabilities of the outgoing developer, what are the rights and liability of the society per se, what are the rights and liability of the incoming developer, what are the rights and liabilities of the people those who have purchased in the new portion of the society redevelopment, and what are those provisions under which the RERA has accepted that the societies are also the co-promoters. Bringing to you today a very renowned and very learned advocate who has been tirelessly writing about various subjects, including RERA, including real estate, including various other things. On my screen, Advocate Aditya Pratap Singh, one of the most renowned advocate on the subject. Very good morning, sir, to bring to you on this particular show. Our viewers are waiting to understand what are those intricacies when the society terminates the development agreement, because lot of societies actually projects are stalled, builder could not complete it, society want to terminate and go in for either self redevelopment or maybe for the new redevelopment or new process with a new builder. Your views, sir, all yours.
Thank you, Mr. Chaturvedi. A very, very good afternoon to you. And you could not have used a more apt word, intricacies. Termination of any development agreement is fraught with intricacies. The builder commits a lot of finance and investment. Society contributes its land, the member moves out. So we must try to understand that termination of a development agreement is a very, very sensitive matter. Termination of a development agreement is essentially a termination of a contract. Under the Indian Contract Act, a contract can be terminated if any of the parties commits a material breach. So if the builder commits a material breach, that is a serious breach of the contract, which causes grave losses to the other side, then the society gets a valid chance to terminate the contract. And once the contract is terminated, the society can proceed to appoint some other builder. But it must also be noted that any event of termination of contract also runs the risk of inviting legal proceedings. If there's arbitration, it may result in arbitration also. And therefore, several legal intricacies come into play, which depend a lot on the nature of the relationship between the society and the developer. Now, let us understand the conventional development redevelopment contract. The society, as we know, redevelopment takes place once the plot of land has been conveyed to the society. So the society signs a development agreement which is registered and stamped with the developer, which permits him to enter upon the property, demolish the building, and construct. At the same time, the society also signs a power of attorney with the builder, which enables him, which enables him to accept flat bookings, apply for permissions, clearances, and so on. Now, whenever a termination of a development agreement takes place, the society also revokes the power of attorney which is granted to the developer. So, in such cases, in logical course, the following intricacies will result. Number one is that first and foremost, is that we can expect that that whatever bookings the builder has taken, they would usually remain unaffected. So long as the development agreement was subsisting and the developer has accepted bookings, those bookings will continue to remain intact and the parties will be entitled to the flats. The builder, however, would not be able to take further bookings because again, then the development would stand to have terminated. Second thing is that the society will be at liberty, subject, of course, to any legal proceedings, to look for a new developer. Now, any new developer who comes in, he would like to be ring fenced, insulated from any legal actions which the society may incur because of the termination. So, in such a cases, either the builder may take it on an as is where is basis, in which he will undertake responsibility to face all the incoming legal actions from the erstwhile developer, or the builder might ask the society to cover him by virtue of an indemnity bond, by which the society will indemnify him against all legal expenses that might be incurred for third party or any earlier developer legal proceedings. So usually whenever a second development agreement is signed, the history of the earlier development agreement is always narrated, and all possible encumbrances are detailed so that the new developer is not taken by surprise. So yes, the nature of termination of a redevelopment agreement depends a lot on the provisions of the Indian Contract Act as well as the terms and conditions contained in the contract. Yes, Mr. Chaturvedi.
That is a wonderful insight. But my question is that society sometimes wants to uh, redevelop after the termination. Whether the termination, because the development agreement is registered one, so I believe the termination has to be following some type of cancellation deed to be registered, or maybe just a letter will do to terminate the development agreement, or you need to go for the arbitration proceeding and get the award. What exactly is the legal procedure to terminate?
Well, if the termination is by mutual consent, then it can be by virtue of a termination deed, which can also be registered because it is effectively extinguishing the builder's limited interest in the immovable property. However, obviously, if the termination is unilateral by the society, then of course, in such cases, the registration usually will not happen because the builder will not come. Be a case of unilateral termination, and it is up to the builder, if he is not agreeable with the termination, to initiate legal actions against the society in this regard. So the society can unilaterally go ahead. However, till the time the builder's right to initiate legal action is subsisting, then it would remain vulnerable to that. So, because so to a simpliciter unilateral termination is possible. This is possible by sending a termination notice to the developer, and in such cases, a termination deed is not required. Rather, the society can send a termination notice to the developer. If the developer is silent, means the termination goes ahead. If the developer has issues, the builder can file a suit or invoke arbitration proceedings if the agreement provides for it. In case there's an arbitration clause, then the builder can also invoke a section 9 proceeding before the honorable high court seeking reliefs. So it is up to the builder to initiate legal action. Otherwise, the society can unilaterally terminate by virtue of a termination notice, go ahead, execute a new development agreement with the registered builder, and carry on the development. And while all, and most importantly, this termination will not extinguish the right of flat buyers who come in now, and therefore it goes ahead as it is.
Okay, my question, the next question was this only. What will happen to the buyers, those who actually purchase the sale component in the redevelopment? Because sometimes the society don't own it. They say that we got nothing to do with that, and you just go and take the money from the developer, outgoing developer, and the outgoing developer says that okay, I have already created a third party right in the society premises when the development agreement was in offing. So now the society, the onus is on the society to honor the contract. So where do the new buyer go actually at that particular time for the
I'll
transfer?
give Yes, I'll give a very simple explanation. When the society gives the builder a power of attorney to accept flat bookings, it will be bound by the actions of its agent. So the builder, as an agent of the society, has accepted bookings in the flats. So likewise, it must be noted that the society, so long as the agent's authority was subsisting and the flat bookings were obtained, the society will be bound by the bookings. And therefore, because moment the builder has signed the registered agreement of sale with the flat buyer, then the flat buyer can fully well go ahead, file a suit for specific performance, seek an injunction against the society from terminating the agreement, and he will be entitled to this particular flat for which he has a registered agreement. So, because the society's termination cannot, because society will be bound by the actions of the developer which were undertaken while the agreement was subsisting.
That was the actually view taken by the RERA also, that
Hmm.
they have made society the co-promoter, and the society now duty bound to honor these sales. Thank you very much, Advocate Aditya Pratap Singh ji. Wonderful insight to our viewers. And we are going to call him again, because on various other sessions we require, because now since the subject is open, we are now inviting the viewers opinion, questions and other things. Need be, we may again request Advocate Pratap Singh ji to come on again on our show and answer all those questions. In the meanwhile, we are now surging ahead, and next week
Thank you.
thank you, sir. And next week,
My pleasure.
11 a.m. again, we are going to bring to you another luminary who are going to speak about the self redevelopment. What are those pros and cons? Taxation, funding, NOCs, what are those compliances required for self redevelopment, whether the self redevelopment is already on, or whether we are still need some more compliances, whether the funding is stopped or whether the funding is already started, what will be the contribution of the society. All these questions which we are going to answer you next episode. Don't miss it. Subscribe our channel right now and be with us. Jai Hind.